We received 556 amendments to this report, and so among the groups we agreed that we would not have the vote on the report in April already, because we really want to find compromise texts that will be acceptable to all the groups. So instead, the vote for the report is now foreseen for the session in May. And we have started today with the first shadow meeting on the topic of compromise amendments. I've sent around a list of first compromise amendments to the shadows yesterday, which is going particularly into the issue of territoriality on geo-blocking and on some of the key exceptions and limitations that are part of the draft report. We didn't have enough time since I sent them around to really have a detailed discussion on the compromise amendments yet in the shadow meeting today, but we will have the next shadow meeting on April 14, where we will be discussing the compromise amendments with particular focus on the questions of geo-blocking and on exceptions and limitations. I would just like to explain the approach that I want to take here. I think there has been a lot of fear around the question of geo-blocking, whether getting rid of geo-blocking means that there cannot be any territorial licenses. This is actually not the case, but the proposals that I'm making in the compromise amendments are about making sure that we do not create incentives for companies to use geo-blocking and that we can complete the digital single market. I think what really counts is not the question of whether it's possible to have territorial licenses or not, but that people who live in the European Union, no matter what country they live in, can access legally the content that they want to pay for, even if it is offered from an operator in another country, and that we do not create artificial obstacles on the Internet for the ability to access the rich cultural diversity that we have in the European Union. This is really at the core of what the Commission is proposing also for the digital single market, and this free movement of goods and services has long been the case in the offline world, and I think it is not in the interest of creators or users if people who want to pay for works do not have a legal possibility to do so. On the question of whether or not the European national copyright rules should be completely replaced by a regulation, what I propose in terms of compromise amendments is that we call for an impact assessment that really produces reliable and independent evidence of the open questions around this idea of a European single title, so that this can seriously be considered as one of the options of addressing the fragmentation that has not been resolved by the implementation of the 2001 InfoSoc directive. Regarding the exceptions and limitations, we will be starting the discussion on compromise amendments about the exceptions for quotation, education, libraries, and freedom of panorama. And I would like to point out that these are exceptions that are really widely used already within the European Union, particularly exceptions for quotations and exceptions for the benefit of libraries have been implemented by every single member state of the European Union. And the question or the issues that we have with the failure of harmonization are really that there is no common implementation and that they do not sufficiently take into account the newly emerged digital uses since the InfoSoc directive has come into effect in 2001. Regarding the issue of libraries, we will have a discussion on the possibilities for e-lending. I think there is a relatively broad agreement among the groups already that we want to create possibilities for libraries to lend out e-books and digital works, but that the question is which formats can best facilitate that, and there I make a proposal in the compromise amendments to, on the one hand, have an exception, but on the other hand, to encourage licensing agreements between libraries and publishers at the same time, because I don't think that these options are mutually exclusive, but rather that they target different needs that libraries have. And finally, on the point of freedom of panorama, I think it's also important to note that the vast majority of member states has this option, and that more than half of the member states also allow the commercial use of pictures of public places. And since there has been some confusion about that, I would just like to point out that freedom of panorama does of course not mean that people who are taking pictures of public buildings don't have the copyright to their own pictures anymore. It's just about being able to disseminate these pictures without an explicit permission from the architect. I think that on these points we will be able to move towards a compromise, and I am very willing to take all the amendments that have been tabled into account and arrive at compromise text for all the paragraphs in the report. And I hope and look forward to the cooperation of the shadows on this point, and really also would like to ask them to discuss with the other members from their groups, because there have been a lot of members who have tabled amendments on the same points, and that we can really, among the shadows, negotiate compromises that take all of these different amendments into account. Thank you.
Mr. Cavada.
Merci, Monsieur le Président. Chers collègues, d'abord une...
Thank you very much. First of all, just to clarify a little, we are all obviously seeking to be as constructive as possible, but having said that, there are some procedural issues here. I understand that Ms. Reda finds herself in a difficult position because she wants to manage this properly, but the meeting didn't actually take place at a time when everyone was able to be there. We haven't discussed the amendments. Many of us were here this morning, at the beginning of the afternoon. We only got amendments last night, and therefore it was really not going to be possible for us to do anything much else. Once we've had a chance to look at the substance of the amendments, then it will be a different thing. As far as I'm concerned, Chairman, colleagues, I think you're probably already quite clear about what I think about copyright and related rights. And so really what I wanted to do is talk about those who rely on copyright and the implications for them. I think sometimes there's a bit of a misinterpretation here. There are those 1 in 1,000 who are actually closely affected by it, but there are others, very many too, who use copyright revenue as an additional source of income, and therefore we have to make sure that we legislate for all those who are affected by copyright. Many people are obtaining small sums sporadically through copyright payments when their writings are bought or copied, and there's no security there. And I think that this is something which we've got to look at carefully. We need to remember that there are social implications to this too, where all artists and creative individuals are concerned. I don't want to talk in terms of cliches, but these people involved in the creative industries are people who have approached me recently and who have been concerned about the need to modify copyright legislation and to make sure that we do it effectively. Now, I don't want to waste my time in generalities and superficialities, but I'll just tell you a few of the examples that I have received, because we have actually received quite a lot of correspondence. For example, a composer who told me he's concerned about losing the right of ownership over his work, about lack of copyright and the impact on his creative ability. Digital platforms are going to have a major impact, and because they can be exempted from copyright and exempted also from certain taxes, which is another scandalous situation, but is not relevant to this particular discussion on this report. So this composer is concerned primarily about these issues. There is a strategy, which he calls that of appropriation and exploitation of composers' work by the digital industry. And the illusion is that music is free, and therefore the composer themselves is getting very little in return and is appealing therefore for us to help them. Then I have an email from a writer. So it's obviously something different. It's not Sir Erik Emanuel Schmidt, and it's not one of the great Swedish authors of recent times, but it's an individual who says that authors in general are very concerned because the digital availability of their work is alarming and accounts for only 5% of their copyright entitlement at a global level. There are billions of dollars made by the intermediaries operating on the internet and making available this information, for example, on YouTube. If there are 5 million clicks on YouTube, it's only 5 cents for the author, which is absolutely nothing. An author would therefore have to have 2 billion clicks on anything that he'd written in order to earn anything relevant at all. So what could be done about this, and how can we stop this exploitation of our creative works? Is there any response you have to this? Then another one who says that at a point when revenue from creation is actually exploited, we need to have some sort of consolidation of copyright to have a rebalancing of the legislation in the interests and protection of the authors, because it is with some bitterness that we see that there is less protection for authors, composers, and those in the creative industry now, and we need much greater protection. It's fair enough that surfers on the internet should be able to have access to culture, but not at the expense of those who create it. What sort of culture do we actually aspire to create? We need to protect those in the creative industries who feel that they are being exploited and who feel that copyright is not serving them well. It is clearly the case that there are too many exceptions to copyright, so many that it is actually an empty vessel. It fulfills no useful function, and this is extremely detrimental to the creative industries in Europe, because the only real revenue that creative individuals and writers get is actually jeopardized by this, and this is not serving the interests of disseminating culture. So there's some very serious concerns, and we feel that this is extremely detrimental to the cultural industries in Europe, which account for some 5,000 jobs in Europe, some 553 million it represents on an annual basis. And I think these are all very important points, and I think that we should respect the input that we've received from these individuals. I've had enough of the prejudice against them. I think over and above all these issues pertaining to culture, it's essential to realize that creative works are creative, and they can't just be reduced to another piece of paper which is digitalized and made available on Amazon or Facebook or whatever. There has to be some kind of benchmark for identifying quality of a work and creative genius. It's not just a question of putting any old ebook out there and they're all one and the same thing. Now, these quotations are much more telling than anything that I could have come up with myself, although I am not without experience in this whole area. It isn't from an ideological perspective I'm wanting to say this. I'm just wanting to try to illustrate to you how serious the situation is for the whole cultural industry in Europe if we don't take care of the creative inspiration that we have. Then we will lose so much, and therefore I think that we need to use the Juncker plan if we can, and we need to be aware of the fact that there's too much dominance of the Anglo-Saxon culture anyway, with the links to America, and that any distribution system is not operating on a level playing field already. Look at the cinema. So in the event of negotiations, we need to ensure that we defend our corner with great vigilance and great prudence, because there are hugely important issues at stake here. And I think it's a question of the health and the longevity and the colour that our European cultures offer. Obviously, there's the aspect of territoriality, and I'm not unaware of that. There's a question of transferability, and that's fair enough, but I do think that the absolute essence of European culture is something we need to retain. After all, it's the very basis of our political systems and much more, and we can't accept it being undermined. Thank you.
Mrs. Hannibal.
Yes, thank you, Chair, and very many thanks indeed to Julia Reda for this report, for dealing with all the amendments. I mean, 356 amendments is a huge number, and the rapporteur has been doing a very good job on this, and I'm sure we all wish to join in thanking her. And we are, of course, as has been said, having another Shadows meeting on the 14th of April, which I hope will take us a bit further forward. I've always taken the view as the S&D shadow that what we need to be looking for and aiming for is a balanced compromise, because there are, as we know, various views, a lot of very strongly held views on the whole issue of copyright and intellectual property. And I think sometimes, somehow, we need to find a way through this to reach a balance which takes into account all the views of people and comes up with something which is sensible and workable. And that's certainly been my attempt as the S&D shadow to ensure that that in fact happens. And Mr. Cavada is absolutely right that the creative industries and creative inspiration is very important for Europe. And I feel this more strongly than most because I represent London, which is an absolute hub these days of creative industries, providing incredible amount of employment. So I feel I have got a personal involvement in this as well as a more general interest, and as well as being shadow on this report. And what I think we need to do is to ensure that, and I'm sure we agree on all of this, that creators and consumers should be given a better deal. And sometimes I think we view these two in competition, that we're either talking about creators or consumers. In fact, they're both on the same side. I mean, they're both part of this, and I don't think that there is the rivalry and the competition that sometimes we think that there is between the two, and we want to work towards the interests of both of them. Like I'm sure most members of this committee, I've received vast amounts of lobbying in literature and statistics and opinions on this report. It's been a long time, in fact, since I've received so much lobbying on an issue, which just shows you how important it is and how we need to make sure that we do get it balanced and that we come to a sensible conclusion in this report. So where we go from now, I think, is that we need to identify some of the things that we are having to face. And we need, obviously, to be looking not only at what has happened in the analogue world and to reviewing the 2001 InfoSoc directive, but we really must now focus much more than we have done on the internet. The internet's provided massive opportunities, and essentially, although there are issues with the internet, essentially it's been amazing, actually. It's been fantastic for all of us. It's allowed us a freedom and an opportunity to communicate, to do things, to see things, to enjoy artistic, creative endeavours and all sorts of other things. So we shouldn't forget how much of an advantage and opportunity the internet actually is. But what we must do within the context of this and the context of this whole report is to ensure that creators' rights are given prominence, that we work on the basis that creators should be adequately and properly remunerated and compensated, and this should apply to works on the internet as well as works in an analogue environment. So the internet and how we deal with the internet is absolutely key to this whole question, and we must put creators' rights and creators' remuneration at the core of all of this. As I said before, the creative industries are very important to our culture, to our entertainment, and in fact to jobs. And we all have an interest in this, because I don't believe that there is anyone in this room who doesn't have some contact at some level with creative industries, with entertainment, with whatever it is. It involves all of us, and that's of course one reason why it's so interesting. I've written my own amendments in this spirit to try and find this balance, and to make sure that we come up with something which is acceptable to most members of this committee and something which will be agreed by this committee. In terms of what Madame Reda said, I think we are very much working towards agreement on some of the issues that she mentioned. Territorial licences, I think I'm actually very pleased to hear what the rapporteur has said on this, and I think that we need to discuss this further, but I think there's certainly a good basis for agreement there. And in terms of looking at a cross-Europe copyright title, I think it would be very helpful if the Commission did an assessment on that, so I would welcome that. The whole questions of exception and limitations, we've obviously had lots of discussions on this, and there will be further discussions, but I think now most of us are broadly in the same place on it, though there are still areas which need further discussion. So we have come a long way since this report was first produced. We've had lots of amendments, as we've said, and I think we are really well on the way to coming to an agreement which this committee can accept, and which most importantly does recognise that the creators themselves need adequate remuneration and need to be paid properly.
Thank you, dear colleagues. We have 3 more speakers on the list, and we have something like 10 minutes, so please take this into account. The next one is Mrs. Geringer.
No, Mrs. Comodini.
Oh, sorry, Mrs. Comodini. Sorry. Mrs. Comodini is the next one.
I'll be very short, actually, because I wouldn't like to repeat what I've already said when we've been discussing this report. I would like to thank Mrs. Reda for sending compromises, even though we received them very late in the evening and we haven't been able to use our shadow meeting today appropriately to discuss those. I agree with most of what Mrs. Hannibal and Mr. Cavada have already stated here, especially the point where we should not make this a battleground between right holders and end users, or whoever lies in the middle of the stakeholder spectrum. However, most of the amendments presented already indicate a very balanced and flexible approach that should provide us with some good compromises, and those compromises I can already foresee will protect the rights of all the stakeholders involved through a balanced procedure, through a balanced approach. The amendments presented at times do, however, indicate certain differences in opinions, and compromise amendments need to make a distinction and need to determine where we are really in agreement and where the red lines are for some of our members. I think the way forward is definitely to keep following a balanced approach so as not to prejudice one stakeholder or another. We will also need to identify where conflicts or failures, advantages or successes of InfoSoc lie. I think we also need to identify where we need further analysis of how the implementation of the directive has worked, as well as what the challenges of the industry and end users and creators are. But as Mrs. Hannibal has already indicated, we have had a large number of stakeholders who have already addressed, I believe, each shadow rapporteur. I think there are issues where the Commission will be required or will be asked to undertake further analysis. But just to conclude, I think we should really consider first by identifying the amendments that already indicate some type of agreement. If we look at the vast number of amendments that were presented, it becomes evident that most of those agreements, most of those amendments are identical already, represent the same opinion, and therefore where there is already an identified position through the amendments, I think we could help ourselves by trying to put those together, and then we would be left with the really difficult ones and the really diverse opinions, and then we can also sit down and discuss with a view to coming to a compromise on those. Thank you.
Thank you. Mrs. Geringer, shortly, please.
Thank you very much indeed, Mr. Chairman. The Reda report is the first report which takes into account the rights of Internet users. We're forever talking about what's banned, but we should be talking about what's allowed. And so I very much welcome the fact that there is a section in the report devoted to users and to what users can obtain by means of legal use of the Internet. The point about libraries is important, and bridging barriers between libraries. Cross-border cooperation between libraries and in the context of research and academic exchange is absolutely vital. Up until now, that hasn't been possible because there have been borders on the Internet. There have been all sorts of exceptions in the member states and a lack of harmonization in the EU as a whole. The change to the business model is also important. I don't have time to go into the detail, but all of us want authors to get more and middlemen to get less. To achieve a true single digital market, we're going to have to decide on our definition of territoriality in that particular field. We ought really be thinking in terms of copyright law applying across the territory of the EU as a whole. Regarding the exceptions now listed by Mrs. Reda, they need to be harmonized. That might seem difficult, but we already have a very positive example in the case, for instance, of so-called orphan works, where we have succeeded in obtaining harmonization across the EU. An orphan work recognized as such in one country is also recognized as such in all other countries. Now, I think that is the avenue for us to follow so as to achieve full harmonization in other fields of copyright. In the case of orphan works, that was a first step on the road to full harmonization, and I hope Mrs. Reda's report will be a second step in that direction, and I congratulate her on the work that she has done. I hope there will be some good compromises coming out of this, and that will open the way to new technologies. Thank you.
Kester, shortly, please.
Ja, vielen Dank.
Yes, thank you very much, Chairman. Well, I'd like to take this opportunity to thank Julia Reda for her work so far on this file. I think that her approach has been characterized by an attempt to try and take into account the various interests and the various political groups here in the Parliament. She's made a good effort to try and arrive at a compromise. Now, I don't know what went into the debates about the current proposed compromises, but I think there's something that has to come out at the end of the day in the report, and that is that we need to have a very differentiated view. We need to draw the right distinction between the rights holders on the one hand and the users and the intermediaries, Google, etc., on the other. So you've got these major players in all of this complex, and you need to describe them in a differentiated manner, clearly define them and their roles, so that we can take into account the higher level of complexity in copyright. So I think that that's the key requirement that's going to be made of this report if we're going to get a reasonable outcome at the end of the day. I'd also like to stress what Mrs. Honeyball stressed. Of course, we do have to pay close attention to the creators of culture. They are the key to our culture and its diversity. And the diversity of our culture is something that characterizes European culture. And, of course, with all of the various different languages, we have major differences with the American market. It's very difficult for us to simply take principles from the USA and impose them on the European market. That's an important aspect that we do need to bear in mind. I think that it would be possible to imagine some kind of compromises when we're talking about embedding and linking. I think that we can get a good compromise. E-lending, that's already been addressed. And I hope that under the conditions that have been described and without hurting the creative people in our society, we can get a good compromise at the end of the day. Thank you.
Thank you. The last speaker is Mr. Giorello from DG Connect.
Thank you very much, Chair, members. I will be very brief, but I thought that maybe the Commission should also say some words today as we went through the impressive number of amendments, and we are, of course, following with the greatest attention the discussion. We have seen that the scope of the amendments cover a very large area, so we are looking forward to see how your works will go on and to the discussions on the compromise amendments. From the Commission side, as you know, I can confirm that clearly this is known by everybody. We have the Commission work plan for 2015 has already indicated that we will come up later this year with a legislative proposal on copyright. What I think is important to keep in mind, although of course no decisions have been taken yet, so it's a bit difficult for the Commission at this stage to take a position on specific topics, but since a number of interventions made reference, for example, with respect to the unitary title, to the possibility that the Commission carries out further impact assessments and analyses further certain issues, something that I think is important to keep in mind is that from the Commission side, at least for 2015, what we want to have is as a priority the possibility to come up with a legislative proposal that I would say inject more internal market in the current EU system of copyright. This is important in the logic of the digital single market, so we want basically to be able to go as fast as we can, although we will still need some amounts, and be targeted. But this does not exclude the possibility, then it's not at the end of the story, to look further at other issues which may also be considered at a later stage. And I think it's fair to say that although, as I said, no final decision has been taken, but a discussion on the EU title is something which probably we will not be able to conclude by the end of 2015, but this does not exclude the possibility to look at a number of issues that could be identified as not mature enough to be part of the legislative package later this year for further considerations later on. So this is an important point that I wanted to start making because I don't think we will be able to factor in everything this year, but we also have the possibility to look at it a bit further on. I think that's it for today. As I said, we will will be looking forward to see what kind of compromise amendments you will come up with to the discussions on the compromise amendments. Thank you very much, Chair.
Thank you as well. Thereby we close the discussion. Mrs. Reda wishes to take the floor. Okay.
Yes, thank you very much to the shadows. I'm very happy to hear that there's a general agreement that we will try to come to a compromise text, and I very much look forward to working on that. And also I would like to underline what the Commission has said, that exactly the idea is to, of course, start a discussion on how a European copyright title could be achieved as a long-term goal, but this should, of course, in no way keep the Commission from bringing forward a proposal. And technological development is extremely quick, and the directive that we are evaluating is already 14 years old. So clearly now is the time to act and to come forward with a legislative proposal. I would just like to comment quickly on one thing that Mr. Cavada has said. It was in French, so there may have been an issue with the interpretation, but he did quote something from me where I don't feel adequately represented. I don't know if this was the case, but it sounded like he was saying that my idea for giving access to users within the European Union is removing copyright. I just want to underline that, on the contrary, harmonizing and making exceptions mandatory is, of course, a completely different proposal than removing copyright that will not lead to an end of creation in Europe. I mean, a lot of the exceptions that we're talking about here are already implemented in a lot of member states. The problem is they are implemented differently, they are implemented to a different extent, and there are some countries that have chosen not to implement particular exceptions that are well established across the European Union and that have not led to an end of creation. And I would just like to underline that I perfectly agree with the point that we should differentiate between mere information and creative works. There I absolutely agree with Mr. Cavada, and this is also why in the text of my report I am not talking about content, but I am talking about works, because I think this is a very important distinction. And for example, this is why I'm proposing an exception for text and data mining, because there we have a situation where money is being asked from scientific publishers for simply extracting information from text and not for reusing a cultural and scientific work, and therefore I don't think that this should be subject to copyright protection. So I think we can come to an agreement on all these points and come to a text that will be acceptable to the majority of the committee, and I thank you very much for the discussion and the input you've given today.
Thank you very much. Mr. Cavada wishes the floor. Please, very briefly. Je vous suis, as you would say.
Oui, je vais faire très brièvement, absolument.
Yes, Chairman, it'll be very brief. Mrs. Reda was asking me a question. I think modernized copyright needs to be the rule, and where there are exceptions, they have to be agreed. Nobody should give their work for nothing. Researchers have a right to freedom, and they should decide and no one else. I want to ask the Commission a question. The big single copyright market ought to be an opportunity to put some order into this. The people from Council are going to Facebook and others saying they should be responsible. When they spread terrorist propaganda, they'll be brought to book in certain countries. They'll be brought to book over spreading paedophile material. And why don't we go the whole hog and say that there is editorial responsibility across the board? They should also pay tax where the material is consumed. I want to know what the Commission is doing. That's the way to go, and I think we need to talk about this.
Very much. Thereby we close the discussion.